Hi, all. Today we're talking about interrogations and investigations and the constitutional law around this, which includes some of the key cases that people often know about Gideon and Miranda, and many of the other ways that people think about once somebody's in custody, what happens to their rights. Now, the evolution of the doctrine started in many ways just with the right to have counsel at all. Powell v. Alabama in 1932, since it wasn't always clear that people had the right to bring somebody into court to defend them. And that established the right that in any state, somebody could have an advocate for them in court. And there were a series of other debates of whether indigent defendants had the right to have the state pay for representation. And in general, this was rejected for years. Betts v. Brady in 1942, except for some circumstances. Although over time, many states started to provide counsel, at least in most cases. And by the time the Gideon decision came down, 37 states provided counsel to most indigent defendants, and eight more did it in most practical times, even though they might imagine some cases where it wasn't. Only five southern states, by the time Gideon came down, did not do regular appointment of counsel in felony cases, which in some sense explains why Gideon was so popular. It didn't actually change much in almost any states except for a few. Later cases would extend the right to counsel, but it was really in Gideon that it became a well known principle, even though, if in practice, it was generally applied. But part of the debate was, along with Mapp v. Ohio and others, just the idea that the federal government could require states to do something, even if it didn't change practices in those states that already had it. The main argument here was that you needed counsel because, first, the government hired prosecutors, lawyers, so it obviously was useful. And Justice Harlan argued that since most states already were doing this, it didn't change practice much. But the idea was law is complicated, and having somebody who could translate what the law is to what your case was part of the idea of having a right to counsel. Now, Miranda was different. Miranda was far more controversial when it came up. There was a whole series of cases coming up around forced confessions, whether that violated people's constitutional rights. And some of the earlier cases where the court intervened were cases where defendants were literally beaten until they actually gave a confession, or they did other kinds of inherently coercive kinds of like interrogation. One case eventually came up which started to say, look, it isn't just that the confession may be unreliable. The idea was when you beat a confession out of someone, it may not be true. And this becomes a dynamic we'll see throughout the course. Like, do rights exist because it's the best way to get to the truth, getting a response or outcome that actually matches whether the person did the crime or not? Or secondly, are we protecting rights just because of the dignity, individual human rights, regardless of whether it's getting to the truth of the matter? Watts v. Indiana was notable that it said we want to prevent bad police practices, irregardless of whether it's getting to the truth or not. But a series of other cases would lead up to saying, both at the federal level, but also then at the state level, that you really needed to have some protection when you're being questioned. For example, in Messiah and Escobedo, the problem was, what is voluntary? What is coercive? Are you breaking somebody's will? And essentially, when you finally get up to a federal right, which itself was only established in 1964, that you had a right to counsel during interrogations at the federal level, it almost immediately jumped in Miranda to, does the same principle extend to states? And in the majority opinion, the basic holding was, you need, quote, procedural safeguards that are effective to secure the privilege against self-incrimination. The right against self-incrimination had previously been seen as a right that existed when testifying in court. Now it was being extended in the process to the point where you're in involuntary custody. Note, the right against self-incrimination would not be extended to when you're first questioned in a car, in any kind of stop and frisk situation. This right against self-incrimination, which had previously been at the part of the process during trial, was now being extended to this point, involuntary custody. And the idea is you need to have the right to silence to ensure the continuous opportunity to exercise that right, that you have to be informed that statements can be used against them, and that the lawyer will help make sure that the rules are followed. And the reason in custody interrogation was considered coercive is that no one often knows what's going on in private. So, unless there are rules, we don't really know how coercive the whole questioning was. The majority notes that police manuals had a whole set of rules to try to trick people into confessing. And the right against self-incrimination really doesn't exist if people don't know they see it as important. Now, there were a number of important dissents in Miranda. Justice Clark said, deception, interrogation, that's all part of the game of policing. He'd prefer to concentrate on due process and the bad police procedures that are really the problem. Harlan had an even more extensive dissent. He notes that we really want to keep pressure on defendants, and he notes that in the Sixth Amendment, the right to counsel is not really explicitly cited to. And he wants to make sure that you don't want to have honestly obtained confessions deterred from going to court. And he notes actually that if the police are willing to lie about whether they told people about their rights, it's very hard to enforce this right against false confessions, since the police can say, oh, we told them their rights. What's the problem? And the person can say, oh, no, they didn't, but how do you prove it? Essentially, he argues this is only going to punish honest police officers, not dishonest ones. So across the board, there are problems and debates over Miranda. And I will note the white dissent actually had an alternative idea that's saying, instead of just making sure people have the right to silence, why not require that there are transcripts of every interrogation so that judges can look over them later to say, is this a good interrogation or not? And it's an intriguing idea that instead of the right against self-incrimination or the being told your Miranda rights, we had a recording of every interrogation since this date. So it goes to the idea that there are different directions any rights could have gone in retrospect. Now, following Miranda, there are a whole range of cases applying it. When you could have a confession, did it extend to police detaining during a stop on a car? And the answer was no. Roadside questioning under what was called Berkmer v. McCarthy is not custody. So Miranda warnings weren't needed. There was also other cases limiting the ability of police to try again. You had to wait, I think they said in that case, 14 days before you could try to question them if they didn't want to initially. And there was also cases that said a confession at a suspect's home, followed by their rights read, followed by a later concession when they were aware of the rights, that confession could be admitted. And finally, after many decades with a more conservative court under Dickerson v. United States, there was an attempt to overturn Miranda But even conservative justices who had criticized Miranda said it was so well established they weren't going to overturn it. Now, along with the right to counsel, there's also, is counsel effective? And whether counsels were ineffective would become an increasingly important part of appeals. And given, as we've discussed, that counsel often is putting in minimal time into most of the cases that they have, especially with indigent defendants, a lot of the counsel is pretty ineffective. And so there were basic standards laid out for when you could bring those cases of ineffective counsel and when you couldn't. And we'll talk more about those in actually further cases in the future. But Michelle Alexander lays out the impact of all these cases, all of the problems. Because once arrested, one's chances of ever being free in the system, as she notes, end up being pretty slim to vanishing. Yes, defendants typically can ask for legal representation, but it's usually not that effective. Most Americans pretty much have no idea how common it is for people to be convicted without really having benefit of legal representation, or how often they plead guilty to crimes they didn't commit because of fear of mandatory sentences. And we'll talk more about plea bargaining in the next class. And in Gideon, while the Supreme Court ruled that poor people were entitled to counsel, people go through often with no lawyer, or a lawyer who doesn't have time or resources to really pursue their cases. And the problem is 80% of criminal defendants are indigent and are unable to hire a lawyer. But our public defender system is so inadequate, how much of a difference does it make? And she goes through the stats again of defenders who have 100 clients at a time, and they really have very little time to pursue any case in depth. And so people may end up languishing in jail for a long time before trial without meeting their attorney, much less getting a trial. And children have even less status under the law for a large series of cases that gave them few rights vis-a-vis people having intervention to make sure that they're under the surveillance of the court. So that's the discussion this week on interrogations, the right to counsel, and the range of cases that were there. Talk to you next class about plea bargaining and the challenges that has within the system.